seminar.
Institute. Yeah, I got one of my Jonna Main Bailey. She went up to that. So
good for her. Good for her. Hey, everybody, welcome.
Hey, we're here.
It's a cast of characters that impact litigation.
I didn't even know we were on. We're chatting away.
We're just having a great time with our friends, you know. Aaron, you're doing good. You look like a beautiful day in Colorado today, I hope.
Doing good. Yeah. How about you guys?
Well, the green is coming to the trees gradually, and it's a great spring day. The last frost may have hit last night. So. Hey, let's start off right away with our litigation question on the Ukrainians. We're just talking about Ukraine. We want to mention what we're looking for in Ukraine here, Greg?
Yeah, I mean, we are trying to do part 2 of our Ukrainian litigation. So part 1 was a big success. We got the USCIS to back down and admit that Ukrainians that came on parole are automatically work authorized. Part 2, we're trying to get the illegally charged I-765 fees returned. And Chuck, I don't know if it's going to be in the same case or not, but we're also trying to force the Social Security Administration to also comply with the law and give the same benefit that refugees get, which is an unrestricted Social Security card. Those are the 2 things that we have left on our list to accomplish for Ukraine. But we need a plaintiff who's residing in the District of Washington, D.C. for federal court, and that's we're getting close, but we want to sue in that district, and but we have to sue on behalf of a resident. So that's the delay right now.
All right, so there's that. Let's talk about our joint delay litigation case with Ayla. This is actually popping along quite well, isn't it, Aaron?
Yeah, so we had a little contested motion that got resolved over, I think, since the last call, where the government asks to stay all discovery pending the resolution of a motion to dismiss, which does not yet exist, has not been filed, and we opposed that, and the judge agreed with us and denied the government's motion. She did extend slightly some of the deadlines, but other than that, everything should proceed apace. So we were happy with that.
Now, on the deadline issue, just because a judge moves a deadline out doesn't mean we have to wait, right? No. So we're moving forward on the original schedule. The government, of course, if they want to drag their feet, they've got an extra, I think it was 30 days she gave them to drag their feet. But their motion to dismiss is still due.
The 31st, I think.
31st. So it's still due in 10 days.
Yeah. We haven't had any movement on on any of the cases since last week when we talked.
All right. So we had that big push last week, and then once again, now when the government files the motion to dismiss, what happens in a case like this is the government, they obviously don't want to be forced to do their job. For want to put it a better way. And so they're going to submit with the motion to dismiss. They're going to argue, you can't sue us to do our job. You can't do that. It's illegal. And they're going to submit as part of their argument something called a declaration, probably from the head of the 601A unit or the head of the Nebraska Service Center or somebody in Washington, D.C. that's in charge of this issue. And they're going to say, here, woe is us. We have too many cases. We don't have enough people, and it's taking a long time. That's what they're going to say. What we're going to say in response to that is, 1, BS. 2, we're going to depose you. We have some questions for you. So we'll be filing, and we're actually preparing now. We're getting our discovery ready to file the moment we get that declaration from the government. And the court has not stayed discovery. So we get discovery during the motion to dismiss period. Once the government files a motion to dismiss, I think we have 2 weeks to respond to that. Government has a week to respond to that. The court has set the next hearing date, I believe, for May. Has she set a date in May? Not set a date. We haven't picked a date.
We don't have a date yet.
They pick a date, probably May. So again, because I know lots of people are now watching this live that are part of our plaintiffs. This is how lawsuits work. Nothing's automatic. Doesn't happen overnight. But the mere fact that 70% of our plaintiffs had their cases physically touched and looked at, that's a big deal. So we'll keep pushing from our end. Your lawyers should keep pushing from your end as well. It's actually kind of stunning, Aaron and Greg, that more haven't been approved, which actually supports our lawsuit.
Mm-hmm.
You know, because we have plaintiffs that are 3 years old.
Yeah.
I mean, this is nightmarishly bad for the government. The fact in the 2 months from filing, they've worked on one case. What are the odds of that? It's like the odds of none of our plaintiffs having an RFE.
Right.
None.
Although we also know that they're not working. It's not a question of first in, first out. They're not working on any of the cases. Every month that goes by, when you look at the processing times, it's another month that's added on to the total. And we've seen that for a while, which means that it's basically a case line that is inactive.
Yeah.
They're not working on.
Well, they're not working enough to stay ahead of the income that are coming in.
Well, right, but we've also looked at the data, and there's barely any
Yeah.
approvals that are.
Oh, last year
they're just accepting. They're accepting money for a service they're not providing.
Yeah. Last fiscal year, they didn't adjudicate enough cases to meet the people that filed.
Right.
So
I mean, it's pretty clear they don't have anybody working on these cases. That's the problem. The problem is not that they're overwhelmed with applications. The problem is they don't have anybody working on the cases, and no one's getting decisions, no matter how long you file.
Yeah, the rule of reason cannot apply if there's no reason involved.
Right.
I mean, we should put that in our brief.
Greg's point that it's not just that it's that we're questioning first in, first out. It's that nobody's working on the cases is important, I think, because even if we were to assume that it's true that they take the first in and first out, and that's their policy, which is not, but let's assume that for a second. Still, if they've made policy decisions or allocation of resources decisions, which mean that nobody's working on the cases and the processing times have exploded to this extent for this benefit, whereas they are not seeing the same kind of explosions of times for other benefits, there's something going on, right? Mm-hmm. And so we need to know why, and we need the government to explain why that's reasonable, and we know the answer, it's not.
Yeah.
This sounds like a great newspaper article. How the government steals your money and it doesn't do anything for you? How does that work? Oh, we'll find out in the AD litigation for Ukrainians. Hey, so that's where we are this week. Our EB5 litigation, we have filed our response to the government motion. And I think we have a really good response, actually, to the government motion. And I do have to update one thing today. I have to substitute an exhibit today for when I forgot, my fault. I forgot to redact somebody's birth date, my bad. File that today. But I suspect the government will, I think their reply is due, I think, this week. I think they got 7 days for a reply or 10 days for a reply. Maybe it's early April. And then I think the court will have a pretty quick decision on this case. This judge has not let motions sit around doing nothing. So we've got that. Another case where we have this monumental amount of evidence that they're not taking cases in order. I mean, we literally, some brilliant dude figured out what Greg figured out and how to get data and from their website. So there we go. We're good. Hey, Greg, do you want to mention our current sign up for litigation? This is the not the 601A, but the 601 application delay.
Yeah, so we have two cases that we're onboarding right now. This is one of them. People get confused between an I-601 and I-601A. They are different processes, different application types. But a 601 application, for this case, we're working on for people that filed. You can use the 601 for lots of different kinds of applications, but our focus here is on immigrant visa applicants processing at consulates abroad. So if you have an I-601 filed because that you're waiting, and most of the time it's going to be people waiting abroad, I guess.
Because you went to the consulate. You went to the consulate, were denied.
Right. If your family member or whoever has filed that 601 on there, this is it. They are experiencing delays very similar to the 601As as far as the length of the delays. It's a couple of years at least on those cases. So we are pursuing that. We're doing it a little bit differently. We will probably be filing multiple I-601 cases in batches. So basically, once we get to a smaller number, we'll file a case, and then we'll file another case probably a few weeks or a month or two later that will look similar and in a different court. And that's how we're trying a different approach for this particular case. So that's the 601s. If you go to our website, IMMPactLitigation.com, just you can see the spelling at the top of the screen on the right. But just go to IMMPactLitigation.com with 2 M's, and you can see the onboarding for that case. So Chuck, that's a 601 case. There's a questions document on there if you're not sure about it. Prevailing wage delay. This is like I've loved this case because it is well, first of all, I shouldn't say I love it. I don't love the fact that people have to sue in this case, but I love the fact that we're taking this on here because this is such a problem. So if you're filing for permanent residency based on a labor certification, which is a big chunk of the people that file for green cards through employment, you have to get a prevailing wage determination first from the Department of Labor. That's an application. If you filed an H-1B application, you already know what the government does. They go onto their website and they look up your job and they look at the wage and they put it on a piece of paper and then they send it back to you. And it takes them, what, Chuck, 5 minutes, do we think? Probably.
Oh, yeah, it can't take more than 5 minutes.
5 minutes if they're going for coffee in the middle. And that's all that, but they are taking a year to give you their 5 minutes. And that's not just bad from the perspective of being able to get a green card, because you can't get to the next stage in a perm application until you get that wage. But it's also causing a lot of problems for people on H-1B visas who need to extend through AC-21. They have to have a perm application that's at least pending a year, or the I-140 is a year. Anyway, you can't get to that stage to be able to get more time on your H-1B unless you have this prevailing wage done on there. So it's not only screwing up, making people wait longer for green cards, but it's also throwing people out of status because they can't keep their H-1Bs valid. So it's a very serious problem. The Department of Labor has, they've been blaming COVID. They've been blaming a lawsuit that we filed a couple of years ago during the Trump administration when they tried to do something pretty terrible on prevailing wages that we sued successfully on. But they've been using a lot of excuses for why this went from something that used to take 6 or 8 weeks to something that's now taking over a year. And they will respond. Historically, they do respond to litigation. So we want to get this thing filed.
By the way, Greg, I was just looking at the prevailing wage the perm reg from 2007.
Yeah.
And it said this: so the department estimated SWA staff, SWA is an old term for us gray-haired people in state workforce agency, would spend 1 hour on average to process job orders and determine the prevailing wage. Because back in the day, you would place your job order at the same time. So clearly it's less than an hour. And the average is, you're going to love this, the average hourly rate for staff is $35 an hour. So they're way cheaper than USCIS, whose hourly wage is somewhere around $3,000 or $4,000 an hour to get their job done. But even back then, with doing other things, which obviously took more time, took an hour, it clearly can't take them very long.
So it's a regulatory thing with respect to them having to do the prevailing wage, but it's not statutory, is it?
Is regulatory, as I recall it.
Right. So if they wanted to solve this problem, they do have the statutory authority to make it like the H-1B, where they're just sort of like auditing or checking after the fact, as opposed to doing the lookup themselves. And they can get them. So they really could probably solve this problem if they decide to do some rulemaking, and maybe this litigation will push them along in the right direction.
All right. So there we go with that. I know Aaron's got to go shortly. We're going to answer some questions today.
Yeah.
Oh, one last piece of information. There is no news on diversity lottery. There you go. Nothing. Nothing. Well, Alyssa, good to see you. Brittany Eastman. Yeah, Jesse would tell you. For instance, in a case, was there any communication with the government implying they would process cases getting older and fight the ones? No. There's nothing like that. We'll see the government's position here shortly. Should be interesting. Gustavo, what does the order denying stay mean is published in the 601A website? That means as Aaron mentioned, the government wanted to stop us from asking them questions because they're going to, at some point in the future, maybe file a motion to dismiss. The court said, no. denying a stay. That's what that meant. Hey, y'all. Hope that I saw you sued on H-1B. Thank you for that. There's no way this year again. No, I didn't sue again on we didn't sue again on H-1Bs. But this is interesting, Greg. The massive screw up on last week. Really, they didn't think that the last day the usage would be higher.
Yeah.
So maybe it might crash the system. Nobody thought that.
Yeah, not great.
You know, what this suggests to me, though, is that we're going to see more than 500,000. That's what it says to me.
Oh, I think it'll be more than that.
Oh, I think maybe 750,000. You think it's going to be higher than that?
It'll be, it's not going down.
I mean, at this point, you have to be a fool not to get multiple employees.
By the way, I got contacted by somebody. I posted something on LinkedIn the other day about this issue with the scam that we sued over, which, just to remind people, and I hope people from USCIS are watching this. We know that they watch us sometimes, but so this is the scam that USCIS will not solve. If you file an H-1, if an employer files an H-1B registration, it costs them $10. Is it still $10 this year, or did it go up?
Next year it's more. This year it's $10.
Right, still $10 on there. And the rule is that an employer cannot file more than one application for the same person for basically the same job, I guess.
Yeah.
I guess that's what the rule is.
Or a closely related employer, apparently.
Right.
So.
Right. But there's no rule that says that 10 different employers can't file applications for the same person, and each application gets its own chance. So if you're just average Joe, who's abroad that wants to get, say, 1,000% increase in your chance of getting selected for an H-1B visa, get 10 different employers to file for you. Now that might sound hard. It ain't that hard. There's
people advertising on the internet.
Right. There's this whole world of middlemen that will and I had one guy contact me and said he has had at least 100 contacts by email from companies that are offering to get him into the lottery. There's a whole industry out there that's doing it. So all these people are and these employers that are filing it, they actually might be legitimate jobs that they would go and work for. But it's still a scam because you're able to game your chances of getting an H-1B visa just by getting multiple job offers, as opposed to Dr. So-and-so who's going to work in for-profit hospital in some, shortage area. He gets counted against, and he only has one offer because it takes 6 months for a hospital to figure out, whether this doctor's qualified and has that's the problem on it. Is some of the most valuable people that we need are in the most complicated situations where one offer is all that's reasonable for them to actually present. So anyway, that is what's happening with the H-1B, and there is a elegant and simple solution that doesn't require them to change anything in their process, which is to change the algorithm so that they will only count each individual beneficiary once on there. So you can have 10 employers file for you, but your chances should be the same as the person who files with one employer. It's a very simple fix that they could solve this problem by doing that. They don't have to change anything in their application process. They don't have to change anything on the website. They don't have to change their fees. They don't have to do anything. All they have to do is just change the back end algorithm for how they get selected, so that they are picking the beneficiary rather than the employer.
But they won't.
Right. And it's not like they haven't known about this. We sued them last year on this issue. They've had a whole year to work on it. Well,
my FOIA litigation is now pending on the data on this. So we'll see what happens with that.
Yeah.
Erica's husband's at the 36-month mark now, says, this is crazy. 43-month. Yeah, Potomac went up again. This would be a great amendment to our complaint, because I think Potomac went up again, Greg, on their processing times.
It should be going up every month, because when you don't work on any cases for the month, that just means that there's another month's worth of cases to add on. So, unless there's a lot more applicants than normal, it should be every month. The processing time should be increasing.
Potomac still says 39.5 on their current website, but we all know what's going on.
Yeah.
And what will be different, DV 2020? It is one case. Yeah. There will be one decision with multiple orders. Because, for example, in our Go appeal, Remember, we have a cross appeal. We wanted more visas. So if we win, maybe we'll get more visas. Well, we'll see. But it will be one decision. Kim Guardado, any new information about the work approved? No, we floated that. We floated that. I don't think it.
That's the kind of thing when we're getting closer to a settlement, like, where if discovery gets ordered, that's when I think we'll start hearing from them about possible solutions like that.
All right. Here's a question: when a 601 waiver, does it mean the CAC shows the date updated but still refused? Basically, you need to don't track the CEAC. You need to be tracking your USCIS receipt number, and when that says approved, that's when you need to go to the CEAC system. Kiara, you think faster filing batches based on the time? I don't think it has anything to do with how it's filed. This is government disorder. This is just really bad.
Well, that all assumes that they're working on anything.
Yeah, which they don't appear to. They don't appear to be. When can we expect the first 601A to be filed? Well, we need a couple more plaintiffs, don't we?
Yeah, I mean, we're doing a push this week with immigration lawyers around the U.S. to make them aware of the case, because with in the 601As, a lot of the plaintiffs found out about us through their lawyers. So hopefully that will be the case again. On there, but hopefully soon.
Once we have them, it should be quick.
Yeah, I think so. Approved I-130 601A, would they just give interviews at field offices? They used to do 601s at field offices until they consolidated them in Nebraska. So, yeah, they could do that. But your problem is the officers in the local offices are not trained on provisional visas, provisional waivers. I'm not sure you want untrained people looking at these.
No, and, Chuck, if we're sort of trying to guess what's happening, it may be that they've transferred these cases and told them to hold them until they get information, until they basically do some training for them on how to actually adjudicate.
Yeah. I'm not sure that's a question, but Ricardo, struggling family, our end goal is to have approval as quickly as possible. That's right. Our goal is to get it approved as quickly as possible. But we have to go. We are constrained by the court. So we have taken this to the next level. Now we're playing the court's game. Lawyers from your lawyers can do. Well, I mean, there's no reason you can't call and ask for an expedite. Hey, here's my situation. I mean, immigration's supposed to accept expedite requests. Somebody dying, is something terrible going on? Do an expedite request. If you do that, let us know, by the way. We've seen 5 minutes from our date after it was filed when we were approved. I don't know what kind of mandamus case you're talking about. Honestly, I don't know what you're talking about, Ricardo. I'm sorry.
I mean,
I think Ricardo was talking about 601As. I thought he asked a question earlier about that. He did.
I'm sorry. I didn't see it.
It's a 601A question.
Oh, okay.
So Ricardo, to answer your question, should you withdraw and file an individual case? I don't know. I mean, you should think about what's best for you. If you withdraw from the litigation, you kind of start from ground zero and start your own.
Deadline's reset.
Yeah, the deadline's all reset. Are there advantages to being in your own case? Yeah. Are there disadvantages? Well, mainly hiring counsel to represent you individually is very, 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 very
way
much
more expensive.
So, but if that's what you decide to do, you let us know and we'll get you withdrawn from the case.
Right.
Yeah.
The advantage of individual cases is largely it's easier for the government to just basically get rid of one case quietly versus a mass litigation where that's probably less likely. But it's a big cost savings if you do it. A lot of people don't have the luxury of being able to sue on an individual basis because they don't have the money for it. So this is we've come up with this new way. It's really sort of a new kind of litigation by doing these mass cases to give people the ability to litigate their delays when they previously didn't have that opportunity. So.
But somebody, this is another part I think we talked to the government about. We know they told us to talk to government lawyers. See, we don't talk directly to the USCIS. We talk to their lawyer.
Right.
And their lawyer has brought this back to them, but we haven't heard back. Here's the reality. If you got a travel permit to travel and come back in, you wouldn't need a 601A waiver. So they could make all these cases disappear tomorrow. So Daniel, when will be the first waivers be sent? We talked about this just a second ago. For more detailed benefits for this, will essentially work as advanced parole. Again, basically, yeah, it would be an advanced parole. But again, there's no benefit because the government hasn't agreed to anything yet. So we'll go from there. Not only should they approve our waiver, but they also allow us to have a change. Yeah, well, that would require a change in the law, unfortunately, or a legal entry. Local lawyer recently filed a mandamus for 601A. She says the U.S. only approves over 2 years and has to file to dismiss. I don't know what that means, but you can file whenever you want to. Whether you're going to win the case, if you only filed a month ago, probably zero chance of winning that case. So really just a question of looking at the time frame a case has been pending. Because you're battling an uphill battle with the courts. The courts don't want to be inundated with these cases either. So if they set in a standard says, well, you can't file it till it's been pending for 3 years, that screws everybody. That's why sometimes one-off cases aren't the best kind of case to bring. You all think you'll be accepting future plaintiffs for 601A? Well, Aline, we shouldn't need future plaintiffs because we've asked for class action, which means everybody would be covered by whatever we end up getting from the government.
Right.
Don't know what's going on there. Can we go all news and speak up about hardship? Yeah, go to the press. Go to the press and talk about this. That's how. There's a recent thing that happened just last week. There was a group of Ukrainians that came in within a parameter timeline and only got 1 year, whereas everybody else before and after them got benefits.
Yeah.
And they screamed bloody murder through the press, and they acted.
Yeah.
So going to the press will not hurt you. It will not hurt you in these cases. She filed 2 minutes and her current only would adjudicate the case over 2 years. I don't know who the lawyer is. So, I'm happy to help her if she needs help. When will the first be? We already talked about that, Danielle, a little bit later. Mandamus lawsuit, and this is a mandamus lawsuit, but it's under the APA, and it's designed.
APA is a statute that allows for that sets the parameters for how government agencies do things.
So, there you go. That's our questions for today. Great talking, everybody. We'll be back live next Tuesday at noon. I'll be live tomorrow at 1. Anybody else being live this week in there?
No,
I'm
writing deadlines.
Who thinks Greg's beard looks awesome, by the way? Good look, Greg.
I'm trying to figure out how to do the grooming and all that. It's
a good look.
Complicated. It's complicated.
Just don't turn it into Hemingway. Just don't do the Hemingway thing. But it's good. All right, you guys. Talk to you next week.
Bye.